I'm Lane Harvey, and I'm going to talk to you a bit about temporary relief in a family law case. You know, when people make a decision to terminate their marital relationships, what usually ensues initially is chaos. The way all of our families evolve, we have a division of responsibilities which may be somewhat informal, but it nevertheless exists. Someone takes care of children, someone takes care of paying bills, someone has this assignment or that. All at once, when the family breaks up, without usually very much warning, those responsibility assignments are gone and there's nothing left but chaos. There is an emotional element to all of this because there's usually anger or hurt to go along with the complete upset of a life routine. Our first task as attorneys for people involved in this situation is to bring some sort of stability during the interim while we get through the process of the dissolution of marriage. That's what temporary relief is all about. I'm going to talk briefly about two things that we need to deal with in temporary relief. The first, of course, is financial. As is typically the case, we all live at the level of our combined earnings. In these days, it's more often true than not true that both parents work to some extent. We maintain a household on the income that's available for the parents and the children. The difficulty with dissolution of marriage is we're suddenly faced with maintaining two households on the same income that we had maintained one on previously. So the first elements that have to be addressed are the division of financial resources and the reasonable allocation of them. That typically will take one of two forms or perhaps both. First, obviously, if there are children involved, is temporary child support. The second is temporary maintenance. Section 501A of the Illinois Marriage and Dissolution of Marriage Act is the section where you begin your quest for temporary financial assistance. That section is very specific. It requires the filing of specific motions with specific factual allegations. It allows for, among other things, the awarding of temporary child support for the parent with whom the children is primarily living, the allocation of financial resources between the parties so that any sacrifices that are necessary because of the split are allocated appropriately and shared. And it provides a basis as to how the family is going to maintain itself pending the final outcome of the case. Section 501A also provides for injunctive relief, things that can be done to preserve the marital assets if there's a reason to believe that one party or the other is trying to dissipate them. That's the first part. The second part, obviously in most families where parents work, one parent may have a job which puts that parent, that spouse, in a financially superior position. The financially superior parent may have to contribute to the support of the financially disadvantaged person. That's temporary maintenance. That comes after you consider the effect of child support. So those are the things that we begin with in terms of trying to reach some temporary stasis on financial issues so that the family can maintain some degree of stability pending the outcome of the dissolution case. The second part, and many times the more difficult part, is what we're going to do with the children. Obviously, the children have lived with the family, and depending on the age of the children, the division of the children on a temporary basis can be very emotional and can be difficult. The first place to begin is Section 603 of the Act. Section 603 provides for temporary custody of the children. The Supreme Court, in enacting the 900 series of Supreme Court rules, has suggested some things that we need to consider in that regard, the first of which is an immediate mediation to attempt to remove the children from the situation. My suggestion is that at the earliest possible date, an order be entered by the court which provides regular contact between the children and both parties unless there is an extraordinary reason not to do so. The important thing that we have to do for the children is to maintain stability and to maintain relationship with both parents. If necessary, after mediation, then there's a provision for hearings pursuant to 603 of the Act to set up a circumstance which will guarantee the children some degree of stability as they make the difficult adjustment to the breakup of the family. All of these things relate to establishing a temporary arrangement for the family during the pendency of the divorce with some degree of stability so that either side will know what to expect and so that the case can move forward on as reasonable a basis as possible. If you would take the opportunity to review the Family Law Nuts and Bolts seminar in October of 2014, the seminar and the materials on temporary relief go into much greater depth, and I would invite you to do so.